Hello everybody, welcome to the National Paralegal College Faculty's Legal Analysis of the News. Today is July 3rd of the year 2012. And of course, happy Independence Day to everybody. That is tomorrow. By the time you listen to this, it will probably be after Independence Day. In fact, it might very well be Independence Day of a different year. But in any case, what I want to cover today is the big story, the big legal news story in recent days, and that is the United States Supreme Court's decision on the Patient Protection and Affordable Care Act, the PPACA, sometimes colloquially known as Obamacare. That rule was upheld, although little pieces of it were struck down, or medium-sized pieces of it were struck down, but on Thursday, just 5 days ago, in a 5-4 decision led by Chief Justice John Roberts, who wrote the majority opinion, the Supreme Court upheld the main components of the Obamacare legislation. And what I'm going to do, I actually did a take on the news a little bit earlier, analysis of the news a little bit earlier, analyzing the way the decision might go. That's, of course, on the National Paralegal College site, if you want to go ahead and look at that. But today I have a little bit of a more ambitious project. What I'm going to do is, rather than going through the procedural history and all the background case law, I'm going to take you through the actual opinion. Now, the actual opinion is 193 pages long, including all of the other dissents and concurrences and whatnot, so I figure most people aren't going to have the patience to read all 193 pages. I've basically read all 193 pages, although I admit to skimming some parts. But what I am going to do is take you through the issues of the majority opinion. I'm not going to worry so much about the concurrences or the dissenting opinion. Those can be dealt with separately, but I am going to try to go through the majority opinion and look at all the issues that the Supreme Court discussed and how those issues got resolved, because as you can probably imagine, in a scenario that is this complicated, and this was an extremely complex decision and an extremely complex piece of legislation, there's a lot of confusion about what exactly the Supreme Court said among lay people, among news reporters, and even among many attorneys. During the oral arguments, which happened back in, I guess, March, maybe late February, whatever it was, to great fanfare. I listened to a lot of the oral arguments, found them very interesting, but there were 4 issues that the Supreme Court heard arguments on. The first issue was whether the suit was ripe, whether the suit should be dismissed under something called the Tax Anti-Injunction Act, which we will discuss. The second one was whether the individual mandate, the provision that requires people to purchase health insurance or pay a penalty, pay a certain extra tax, as the case may be. The third was if the individual mandate was unconstitutional, is the rest of the bill severable, which means can the rest of the bill stand on its own merits, or should the entire thing be struck down? And the fourth was whether certain provisions of the bill were an infringement of states' rights, because the Medicaid provisions, essentially the provisions that tied the state's enforcement of the bill to Medicaid grants from the federal government, was that impermissibly forcing the states to do something. And I'm going to deal with the issues in turn and see how the Supreme Court actually dealt with them one at a time. So let's first start with the Anti-Injunction Act, the issue of can the suit be heard now. Back in I think it was the 1860s actually, quite a while ago, Congress passed something called the Tax Anti-Injunction Act. There's actually a separate statute called the Anti-Injunction Act that deals with something different, but this is the Tax Anti-Injunction Act, which provides that no suit for the purpose of restraining the assessment or collection of any tax shall be maintained in any court by any person, whether or not such person is the person against whom such tax is assessed, before, I guess I missed some of the language over here, this is from what the court quoted, but the point is that the lawsuit against any tax can only be brought once a tax is assessed. In other words, you can't ask for an injunction in advance to stop a tax from being assessed. Once you get the letter from the IRS that says you owe the taxes, you can then go ahead and file your lawsuit to try to get the tax bill overturned. But in the meantime, you cannot enjoin, you cannot ask for an injunction against the imposition of a tax, and the reason for this bill was to protect the government's ability to collect a consistent stream of revenue by barring litigation to enjoin or obstruct the collection of taxes. So the question over here that's relevant to the Patient Protection and Affordable Care Act is the fact that the mandate, the individual mandate, which is the main thing in controversy over here, the individual mandate is a provision that says that if an individual does not purchase private health insurance, the individual is required to pay a tax. Now, the exact amount of the tax depends on the person's income and depends on a few other factors, but basically the tax is going to be usually a few $1,000s, $2,000, something to that effect, for not purchasing health insurance each year. And the individual mandate, as it's known, doesn't become enforceable until 2014. And now, of course, is 2012. And so really the question is that statute, or is that lawsuit barred by the Anti-Injunction Act? If it's a tax, then we have a problem. Because if it's a tax that we're talking about over here, the penalty for not having insurance, well then you can't bring the lawsuit until 2014, and the entire case should be dismissed now and re-picked up in 2014 after somebody's actually forced to pay it. And the Supreme Court says no. The Supreme Court says that for purposes of the Anti-Injunction Act, this is not a tax. Now, of course, that'll become important later on, that when I say that it's only for purposes of the Anti-Injunction Act that this is not considered a tax. But the court says that the text of the statute suggests otherwise. In other words, suggests that it is not a tax. The text of the statute, the text of the Affordable Care Act, I'll just refer to it as the ACA or the Affordable Care Act, shows that Congress did not necessarily intend for it to be a tax. The court says that this was called a shared responsibility payment. If you don't want to buy private health insurance, at least help other people share the responsibility and help pay for other people's insurance, and that it's not a tax but a penalty. There's no immediate reason to think that a statute applying to any tax would apply to a penalty. And Congress labeled this mandate a penalty rather than a tax, and that's significant. And the reason is because the Affordable Care Act describes many other exactions, many other relevant provisions in the Act as taxes, and the fact that the mandate was considered a penalty shows that Congress intended it to be a penalty and not a tax. And furthermore, the court says that the entire Anti-Injunction Act is really just an act of Congress. It's a statute, and it's not a constitutional requirement. There's no constitutional rule that says you can't sue to enforce a tax before it's imposed. And so therefore, since Congress created the Anti-Injunction Act in the first place, it's really up to Congress how it interplays with other rules. How they relate to each other, namely the Affordable Care Act and the Anti-Injunction Act, is up to Congress. And the best evidence of Congress's intent is the text. We've applied the Anti-Injunction Act to statutorily described taxes, even where that label is inaccurate, but the Affordable Care Act over here is best described as a penalty, according to the United States Supreme Court. And so therefore, the Supreme Court, in a relatively short component of the decision, decided that the Affordable Care Act was considered a penalty or a shared responsibility payment and not a tax, and therefore there was no problem with the Anti-Injunction Act, and therefore the case does not have to be dismissed, and we can move on to deciding the case on the merits. Okay, now we can start really getting into the meat of the case. And the second issue that the Supreme Court dealt with, and the one that everybody thought was going to be the dispositive one, is the issue of the Commerce Clause. The Commerce Clause, which is Article 1, Section 8, Clause 3 of the United States Constitution, is the clause that gives Congress most of its authority, far more authority than any other single provision. The Commerce Clause says that the Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. That middle one, sometimes referred to as the Interstate Commerce Clause, is the one that really gives Congress its authority. Most of what Congress does, including setting up huge administrative agencies like the Food and Drug Administration, Federal Aviation Administration, Environmental Protection Agency, most of the civil rights laws, etc., 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 are all based on the Interstate Commerce Clause. Now, what Congress asserted, certainly what the government attorneys asserted, is that the Affordable Care Act was constitutional under the Commerce Clause. Basically, the idea is that people failing to purchase health insurance, if people go without insurance, that's going to interfere with commerce. The system isn't going to work as well. There isn't going to be enough money in the pot for, if people don't buy insurance, for everybody to be covered by insurance to spread the risk around. There are various theories, but basically the idea is this would have an effect on interstate commerce. It would have an effect on the nation's economy if people don't have health insurance, and so therefore forcing people to purchase health insurance should be constitutional under the Commerce Clause. That is how the government's argument went. The states who were suing, the people who don't like the bill, their argument was that it's beyond the scope of Congress's commerce authority, because what you're trying to do over here is you're trying to force people to engage in commerce. Congress can regulate commerce, but the Commerce Clause should not be construed so broadly as to allow Congress to actually force people to buy stuff and force people to do something. And that's really where the arguments under the Commerce Clause went. And of course, the court, like all Commerce Clause cases, first goes through the expansiveness of the Commerce Clause. The Commerce Clause has been interpreted very broadly in the last, let's say, 70 years, 75 years, give or take. Really closer to 80 years, but the courts have really given Congress a lot of authority to regulate the economy. Some of the broadest powers, some of the broadest Commerce Clause cases occurred all the way back in the early 1930s, cases like Wickard versus Filburn. And there was another recent case, Gonzalez versus Reich. Both of them were actually discussed by the court. The first thing was Wickard. Now, I'll tell you a little bit about what happened in Wickard. Wickard was Congress had passed a law regulating the amount of wheat that you could grow on your own farm. And Wickard had grown more wheat than that on his own farm, and he was being penalized under a congressional statute. And his argument was that this has nothing to do with interstate commerce. I'm not buying it in order to sell it. I'm buying it for my own family. I'm buying it for my own use. This has nothing to do with interstate commerce, and Congress doesn't have the authority to regulate it. And the Supreme Court disagreed. The Supreme Court said, even though you personally may not have a major effect on interstate commerce, if all the people in the country, or all the people with farms, or a substantial number of people with farms were to use the same logic and not be within Congress's power, and many people would grow different amounts of wheat or more than Congress envisioned on their own farm, that would have a substantial effect on the price of wheat and therefore on interstate commerce. And therefore the Supreme Court allowed it. And you can see over here, as the court says, under Wickard, it was within Congress's power to regulate the market for wheat by supporting its price. And this was one of the cases, of course, that the government certainly relied on in trying to establish that the Affordable Care Act was allowed under the Commerce Clause. But the court disagrees. Chief Justice Roberts, in his opinion, disagrees. He says that the farmer in Wickard was at least actively engaged in the production of wheat, and the government could regulate that activity because of the effect on commerce. The government's theory here would effectively override that limitation by establishing that individuals may be regulated under the Commerce Clause wherever enough of them are not doing something the government would have them do. So Roberts is distinguishing Wickard by saying that in Wickard you were talking about people engaging in commerce and the government regulating it by growing wheat. Over here, you're talking about people not engaging in commerce, and allowing the government to regulate a lack of activity is a whole new step. And the court says that, to the economist perhaps, there's no difference between activity and inactivity, but the distinction between doing something and doing nothing would not have been lost on the framers, who were practical statesmen, not metaphysical philosophers. I'm not exactly sure who that's a dig at, but Justice Roberts thinks that forcing people to do something, forcing people to engage in commerce by federal fiat, is something that should be beyond the scope of the Commerce Clause. The Justice Ginsburg's opinion, that would rather have seen this statute upheld under the Commerce Clause, had argued, just as the government had argued, that everybody's going to need health care at some point or another anyway, so that you're not really looking at regulating somebody not doing something because everybody's going to enter the marketplace at one point or another, and Justice Roberts disagrees. He says everyone will likely participate in the markets for food, clothing, transportation, shelter, and energy also. That doesn't authorize the Congress to direct them to purchase particular products in those or other markets. The Commerce Clause is not a general license to regulate an individual from cradle to grave simply because he will predictably engage in other particular transactions. And rather, this sort of thing should be left to the states, according to the Chief Justice's opinion. And so the Chief Justice, in the majority opinion in this case, actually said that the legislation is not allowed under the Commerce Clause. If you were following the decision, as I was, at a little after 10 o'clock last Thursday morning, and you saw the cable news shows come on, the first thing they all said is that the individual mandate is unconstitutional! And for the first 5 minutes or so after the decision came down, everybody said that everybody was talking about the unconstitutionality of the individual mandate. And the reason why they were saying that is because they read this part of the opinion first. And so far, Justice Roberts is saying that the individual mandate is not supportable under the Commerce Clause, and therefore, so far, doesn't have a sufficient constitutional basis and should be struck down. So now we move to issue 3, and issue 3 was the issue of, is there another way to get this mandate upheld once it failed under the Commerce Clause? The next possibility that the court discussed is the necessary and proper clause, sometimes referred to as the elastic clause, because it's so bendable and so broad. This is Article 1, Section 8, Clause 18 of the United States Constitution, and it says that the Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, namely the other powers that are listed in Clauses 1 through 17 of that section, vested by this Constitution in the government of the United States or any department or officer thereof. The elastic clause is kind of a clause that says, not only do you have the powers we specified, but you also have other powers that are necessary to establish those powers or to carry out those powers. There was a very famous case, McCulloch versus Maryland, in I think it was 1824, which said that Congress did have the authority to establish a federal bank, and even though the Constitution doesn't specifically give Congress the authority to establish a federal bank, since it does give Congress the authority to regulate commerce and coin money, establishing a bank is necessary and proper to carry into execution those powers. So, since this is a pretty broad way to give the federal government power, perhaps the Affordable Care Act, if it can't be allowed under the Commerce Clause itself, could be allowed under the Necessary and Proper Clause. And the court at the outset comments that although the Necessary and Proper Clause is pretty broad, we have also carried out our responsibility to declare unconstitutional those laws that undermine the structure of the government established by the Constitution. Such laws are not consistent with the letter and spirit of the Constitution and are not proper means for carrying into execution Congress's enumerated powers. In other words, Necessary and Proper Clause can allow Congress authority to do things that are within the spirit of the Constitution, but things that are outside the spirit of the Constitution, Justice Roberts says, are not allowable under the Necessary and Proper Clause. So now let's see how the Necessary and Proper Clause is applied to the Affordable Care Act. Well, the court is not impressed with the idea of allowing this the Affordable Care Act under this clause. The court says that the individual mandate cannot be sustained under the Necessary and Proper Clause as an essential component of the insurance reforms. The insurance reforms themselves, of course, were allowed under the Commerce Clause, and so therefore the government had argued that as a necessary and proper component of the insurance reforms, forcing each person to purchase insurance is something that's going to be required in order to establish those reforms. And the court draws some contrasts and concludes that the individual mandate, by contrast, vests Congress with an extraordinary ability to create the necessary predicate to the exercise of an enumerated power. Congress can't create necessary predicates. Congress has to have the necessary predicates, which it doesn't over here. The course then distinguishes the famous case of Gonzalez versus Reich. That case happened, I believe it was 2005. What had happened in that case, actually a very similar case to Wickard, which we discussed before. A California person who was arrested on federal narcotics charges challenged the federal government's right to preclude her growing marijuana in her own house. Now, that was actually allowed under California law, but there are federal laws saying that you can't possess marijuana. And so this woman, Mrs. Reich, argued that Congress does not have the authority to prohibit the growing of marijuana on private property. If I want to grow marijuana in my backyard, that has nothing to do with interstate commerce. That has to do with my own personal, what I do in my own backyard. And the Supreme Court, using a similar reasoning to the reasoning in Wickard, held that all the marijuana growers in America combined have a substantial effect on interstate commerce, and therefore you can be held to the Commerce Clause. But the court distinguishes that in this case. It says Reich thus did not involve the exercise of any great substantive and independent power. Instead, it concerned only the constitutionality of individual applications of a concededly valid statutory scheme. The valid statutory scheme that the court references is the prohibition of narcotics in general. And certainly even Mrs. Reich didn't challenge the idea that the federal government has the authority to prohibit drugs in general. Whereas in this case, there was no underlying authority that Congress has. Congress, as we saw in the Commerce Clause discussion, does not have the authority to force people to engage in commerce at all. Well, so far things aren't looking so good for the Affordable Care Act. It's not allowed to Congress. Congress can't do that sort of thing under the Commerce Clause. Congress cannot do the individual mandate, enforce the individual mandate under the Necessary and Proper Clause. But there's one last chance, one that kind of runs counter to the entire government's argument throughout the case, really since the Affordable Care Act was proposed. There's been almost a consistent argument from the Obama administration and from Democratic members of Congress that the Affordable Care Act, or the mandate, is not a tax but a penalty or a shared responsibility. But still we have this fourth issue to deal with, and this fourth issue is, can the individual mandate be upheld under the taxing and spending power? I'm sorry, I wrote Necessary and Proper Clause. I meant the taxing and spending power. But let's take a look at what the taxing and spending power has. This is from Article 1, Section 8 in the Constitution as well, and this is actually Clause 1. And the Constitution says that the Congress shall have the power to lay and collect taxes, duties, imposts, exercises, to pay the debts, and provide for the common defense and general welfare of the United States. So, in other words, Congress has the power to impose taxes for the general welfare of the people. Congress doesn't have the authority to do anything for the general welfare of the people, but it does have the authority to tax for the general welfare of the people. So does Congress have the authority to lay taxes on people who don't buy health insurance for the general welfare of the people? In fact, the court conceded, Justice Roberts conceded, that the tax power argument asks us to view the statute differently than we did in considering the commerce power theory. In the Commerce Clause argument that we just discussed, the government said, well, Congress can do it as a regulation requiring individuals to purchase health insurance. If you're going to make the argument that it's allowable under the taxation theory, then the government is not saying that you have to buy health insurance, just that we're going to impose a tax. If you do buy health insurance, you don't have to pay the tax. If you don't buy health insurance, you do have to pay the tax. But there's a very different theory. I mean, one big difference is that, for example, if the individual mandate would have said if you don't buy health insurance, you go to jail, well, that Congress could definitely not do under the taxing power, because going to jail is not a tax, it's a punishment. Then it would have to be valid, if at all, under the Commerce Clause. But over here, Congress isn't making you go to jail if you don't buy health insurance. All Congress is doing is saying that you have to pay a tax. Can that be allowed? And the court continues that discussion. First of all, Chief Justice Roberts goes through a very important principle, and that is that it's well established that if a statute has two possible meanings, one which violates the Constitution, courts should adopt the meaning that it does not do so. In other words, the court is looking at the mandate. Should we look at it as a tax on people who don't have insurance, or as a prohibition on people not having insurance? If it's the latter, the statute's going to fall. If the former, it can pass. And so that's why Justice Roberts is establishing the fact that we're going to try to look at it in the light most favorable to being allowed. And the court says under the mandate, if an individual does not maintain health insurance, the only consequence is that he must make an additional payment to the IRS. According to the government, that means that the mandate can be regarded as establishing a condition, not owning health insurance, that triggers the tax, which is the payment to the IRS. We're taxing you, but it's conditional upon your not having health insurance. Under that theory, the mandate isn't a legal command to buy insurance. Rather, it makes going without insurance just another thing that the government taxes, like buying gasoline or earning income. And then the court further buttresses the argument that the individual mandate is really a tax and not a requirement. The exaction of the Affordable Care Act imposes on those without health insurance looks like a tax in many respects. It quacks like a tax, well, etc. But it says that it's paid to the Treasury by taxpayers when they file their tax returns. It doesn't apply to individuals who don't pay federal income tax because their household income is too low. For taxpayers who owe a payment, it's determined by such familiar factors of taxable income, number of dependents, and joint filing status. The requirement to pay is found in the Internal Revenue Code, enforced by the IRS, and the IRS must assess it and collect it in the same manner as taxes. This process yields the essential feature of any tax. It also produces at least some revenue for the government. Indeed, the payment is expected to raise about $4 billion by year 2017. Now, $4 billion in the next in 3 or 4 years of assessment is really not a tremendous amount of money as far as the government is concerned, but it is still designed to raise revenue and therefore can be considered a tax. And while the court concedes that the mandate is trying to do something, it aims to induce the purchase of health insurance, it need not be read to declare that failing to do so is unlawful. We're not saying that it's a crime to not own health insurance. The Congress is not trying to tell people they have to own health insurance. It's that they have a choice. They can either have health insurance or pay this tax. So there's no other law that attaches any negative legal consequences to not buying health insurance beyond requiring a payment to the IRS. Indeed, it's estimated that 4 million people each year will choose to pay the IRS rather than buy insurance. And then Justice Roberts continues this argument, hammering it home, saying that if the idea were that not owning health insurance were unlawful or criminal, we would expect Congress to be troubled by the fact that 4 million people are going to not do it. The idea is Congress doesn't just pass laws that are going to make 4 million people into criminals. That Congress apparently regards such extensive failure, 4 million people, to comply with the mandate as tolerable, suggests that Congress didn't think it was creating 4 million outlaws. It suggests that the shared responsibility payment merely imposes a tax citizens may lawfully choose to pay in lieu of buying health insurance. And so therefore the mandate was upheld. And because not under the commerce power, not under the necessary and proper power, but under the taxation power. Congress has the authority to require that people purchase health insurance or pay a tax at their own option under its power to tax and spend for the general welfare. Now, Justice Ginsburg actually wrote a dissenting, or a partially dissenting opinion, really a concurring opinion, that agreed that it should be allowed under the taxing power, but Justice Ginsburg felt that it should be allowed under the Commerce Clause also. And one thing that she brought up was that she said that she doesn't understand why Justice Roberts went through a whole, 20-page, 30-page, 40-page section explaining why the Commerce Clause is not a good enough reason for the mandate when he was going to uphold it anyway. And so Justice Roberts answers that. The Chief Justice says that Justice Ginsburg questions the necessity of rejecting the government's commerce power argument, given that it's going to be upheld anyway. So the court says, well, I really had to do it because I think the statute probably meant to be under the Commerce Clause. So if I was going to interpret it under some other clause as a tax, I had to dismiss the most obvious way of upholding it first. So the statute reads more naturally as a command than as a tax, and I would uphold it as a command if the Constitution allowed it. It's only because the Commerce Clause doesn't authorize it, according to my analysis, that it's necessary to reach the taxing power question. So that's why, in other words, first I went through the Commerce Clause argument, and since we found that it cannot pass, we had to use the taxing and spending power. And of course, remember that the taxing and spending power, even though it is considered a tax for these purposes, remember a little while ago we discussed that under the Anti-Injunction Act, it's not considered a tax. And Justice Roberts actually distinguishes it, saying that even though Congress has the authority to levy this tax, for purposes of the Anti-Injunction Act, since Congress didn't really intend it to be a tax, didn't use the word tax, it's not considered a tax for Anti-Injunction Act purposes. Essentially, since Congress wrote the Anti-Injunction Act and Congress could repeal the Anti-Injunction Act, it's really up to Congress to interpret the Anti-Injunction Act vis-a-vis other legislation. And since Congress didn't really mean for this to be a tax, we're not going to call it a tax for Anti-Injunction Act purposes. On the other hand, since it's within Congress's authority to do under the taxing and spending power, we will allow the law to uphold. A very fine point, an argument that turns very, very carefully, and the sort of thing that may not be obvious or intuitive, but that was just Chief Justice Roberts' reasoning. And now we get to the last issue, and the third day of oral arguments back, I believe, in March, when this was being discussed. The states had argued that it wasn't fair, or wasn't allowable under the Constitution, really fairness has nothing to do with it, for Congress to pass a law that was coercing the states to do something. Part of the Affordable Care Act, a very big part of the Affordable Care Act, expands Medicaid. Now Medicaid, by way of background, is a joint federal and state program. The federal government pays for part of it, and the states pay for part of it. But the federal government attaches certain conditions to its funding. The federal government basically says, you, states, you administer it pretty much however you like, but if you want our money, you're going to have to follow these conditions. And there are long federal statutes, complicated federal statutes, which attach certain conditions as to how the states are going to administer Medicaid. So it's partially funded by the feds, partially funded by the states. It's operated by the states, administered by the states, but the federal government has certain conditions and rules that it applies that the states have to follow. Now this was a huge expansion of Medicaid. It expands it to all people, I think, up to that make up to 133% of the poverty amount, which would make many more people, eligible for Medicaid. And so the states had challenged this by saying, there's one more important piece of information. There is a part of the Medicaid statute that's been around for probably 50 years, since Medicaid was passed first in the 60s, that says that if the states don't listen to any part of the Medicaid statute, if the states don't abide by any part of the Medicaid statute, they could lose all of their Medicaid funding. The federal government can take all of their Medicaid funding off the table. So the state said, hey, you're coercing us to do something. You're essentially, by you expanding Medicaid, we don't really have a choice in the matter. What you're doing is you're forcing us to administer this huge new addition to Medicaid, because if we don't, you can pull all of our Medicaid funding. And no state can afford to have all of its Medicaid funding pulled. So many states felt that this was coercive. Now, as a matter of constitutional law, the federal government is not allowed to force states to do something. It can give the states money and attach conditions to it, but it cannot be coercive. And that was really the next issue. They argue, the states, it says that they violate the basic principle that the federal government cannot compel the states to enact or administer a federal regulatory program. And the court concedes, of course, or establishes at first, that the act dramatically increases state obligations under Medicaid. The current Medicaid program requires the states to only cover certain discrete categories of people: pregnant women, children, needy families, blind, elderly, disabled, etc. And the Medicaid provisions of the Affordable Care Act, in contrast, require states to expand their Medicaid programs by 2014 to cover all individuals under 65, over 65 is covered by Medicare, so it's not necessary, with incomes below, or not always necessary, with incomes below 133% of the federal poverty line, which is a much, much higher level than previously allowed, or previously required. And of course, the court goes through the different case laws. There are a lot of case law on what the federal government can force the states to do. There was a case, Prince versus the United States in 1998, where part of the Brady Bill, which required states to run background checks on people before giving them gun licenses, was held to be unconstitutional. Essentially, the Supreme Court said that the federal government is not allowed to force states to run background checks on individuals because states have their own sovereignty. The federal government doesn't get to tell them what to do. A famous case in the early 90s called New York versus the United States, where the federal government had passed a law saying that states are required to take title of their own hazardous waste, certain types of hazardous waste, like nuclear waste, whatever it was, and New York sued, and the Supreme Court agreed with New York. The Supreme Court said, you, federal government, don't have the authority to tell states what to do with their ultra-hazardous waste. Although the Supreme Court, as I mentioned before, has generally upheld the right of Congress to allocate money on a condition. So the question is, what happens, where does this case fall? Does the Medicaid expansion, with the implicit requirement that states follow it or lose their Medicaid funding, fall more towards the side of coercion and therefore unconstitutional, or more towards the side of just a condition to a spending and therefore constitutional? So the court says that we have repeatedly characterized spending clause legislation as much in the nature of a contract. You do this, we will give you money. And the court says that spending clause programs don't pose the danger as a threat to state sovereignty, as a threat to state autonomy, when the state has a legitimate choice of whether to accept the federal conditions. In such a situation, state officials can fairly be held politically accountable, but when the state has no choice, when the state has to accept the federal conditions, then the federal government can achieve its objectives without accountability, just as in the cases I mentioned before, New York and Prince. And the states argue, in this case, that the Medicaid expansion in our case, they object that the Congress has crossed the line distinguishing encouragement from coercion, and essentially that Congress has also threatened to withhold those states' existing Medicaid funds if you don't accept the new Medicaid rules. And the court, in this case, even though the government had won the previous issue that the Affordable Care Act is constitutional, in this case the court agrees with the states. The court says that given the nature of the threat and the programs at issue here, we must agree. We've upheld Congress's authority to condition the receipt of funds on states complying with restrictions, because that's the means by which Congress ensures that they're well spent. But here, the court says that conditions that do not govern the use of these funds can't be justified on these bases. When, for example, such conditions take the form of threats to terminate other significant independent grants, the conditions are properly viewed as means of pressuring the states to accept policy changes. So in other words, if the government says, unless you, Florida, or you, Arizona, or you, California, enact the Medicaid provisions of the Affordable Care Act, we're going to pull all your Medicaid funding, not only the new funding that you're getting now, but also the funding that you've had for the last 50 years, that could be considered coercive. And the court brings some examples. There was the famous case of South Dakota versus Dole, where there was a federal legislation that said unless states raise their drinking age to 21, we're going to cut off some federal highway funds. And those were allowed because the court said the penalties on South Dakota or any state for not doing it, for not raising the drinking age to 21, weren't that bad. We observed that all South Dakota would lose if she adheres to her own chosen course as a suitable minimum drinking age is 5% of the highway funds. 5% is, in fact, the federal funds at stake constituted less than 0.5% of South Dakota's budget. So in other words, while South Dakota didn't want to lose the money, if they chose to go their own route and not to take federal funds and not to raise their drinking age to 21, all they would lose was 5% of their highway funds, which constituted less than 0.5% of their budget. The Medicaid expansion, however, to contrast it with the South Dakota case, accomplishes a huge shift, a shift in kind, not merely degree. The original program, the original Medicaid program that's existed for 50 years, was designed to cover services for people that are disabled, blind, elderly, families in need of dependent children. This one expands it. Under the Affordable Care Act, Medicaid is transformed into a program to meet the health care needs of the entire non-elderly population with income below 133%. It's no longer a program for the neediest among us, but rather an element of comprehensive national plan to provide universal health coverage. And so therefore, the court ruled that this was considered coercive, and Congress could not do this. Congress could not pass legislation that forced the states to adopt these new huge expansions in the Medicaid program without, and forcing the states by threatening to cut off all other federal funding. Nothing, in our opinion, precludes Congress from offering funds under the Affordable Care Act to expand the availability. What Congress is not free to do is to penalize states that choose not to participate by taking away their existing Medicaid funding. In other words, if the state of Florida says, we don't want to spend our money for the Affordable Care Act Medicaid provisions, well, of course, then they won't get the new money that the federal government is offering them, but their existing Medicaid funding cannot be decreased or taken away just because they refuse to enact the Medicaid provisions of the Affordable Care Act. And of course, that really begs the question, so therefore what? So therefore, this section of the Affordable Care Act is nullified or struck down. You can't have a rule that says that the federal government can take away all funding if the states don't enact the Medicaid provisions. Does that have any effect on the rest of the bill? Does that mean the entire bill has to be struck down? And predictably, and I think logically, the Supreme Court says no. The question remains whether today's holding affects other provisions of the Affordable Care Act, and Chief Justice Roberts pretty quickly and summarily dismisses that idea by saying, we are confident that Congress would have wanted to preserve the rest of the act. It's fair to say that Congress assumed that every state would participate in the Medicaid expansion, given that the states have no real choice but to do so. But the idea is that we have no way of knowing how many states will accept the terms, but we do not believe Congress would have wanted the whole act to fail, simply because some may choose not to participate. The other reforms Congress enacted, after all, will remain fully operative as law. And so therefore, basically the only thing out of all the challenges, the only thing that was successful against the bill is that if a state chooses not to expand their Medicaid spending under the Affordable Care Act, which they have the choice whether to do or not to, then they will not lose their original Medicaid funding, although any new Medicaid funding that would be under the Affordable Care Act, of course, would not be available to the states. So, and then we have one final note that Chief Justice Roberts felt compelled to state. It's fairly obvious from a legal standpoint, but maybe for political reasons. Chief Justice Roberts says, the framers created a federal government of limited powers and assigned to this court the duty of enforcing those limits. The court does so today. The court does not express any opinion on the wisdom of the Affordable Care Act. We're not going to tell you whether we think it's a good idea. Frankly, that's none of our business. Under the Constitution, that judgment is reserved to the people. So overall, we of course have a tremendous victory, probably an unexpected victory for the Affordable Care Act. Most people thought that the individual mandate would be struck down, and certainly the commerce power was limited a little bit. The Supreme Court refused, let's say for future purposes, to allow Congress to regulate inactivity. For example, if tomorrow Congress passes a law that everybody has to have car insurance or you go to jail, or everybody has to have health insurance or you go to jail, that would probably be struck down under this case. But under the taxing power, Congress does have the authority to do that because it was levying a tax, but this court did, of course, apply some limits as to what Congress can force the states to do. So I know this was a long one, and I appreciate your sticking it out and listening to the whole thing. Hopefully this will make things a little bit more clear in terms of what the decision was and how it affects the bill. Thank you very much for listening, and have a wonderful, wonderful day, everybody.